actually conducted a formal hearing. I just asked the state to turn over a copy of the search warrant and affidavit. Ms. Collins, let me ask you this. I read your authority. Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Well, can you explain that to me? Because if I signed a search warrant for someone's home, and BSO goes to their home and executes the search warrant, and they're there, they give them a copy of the search warrant.
Correct. But
Upon
in
its
this case,
execution.
it's Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
Yeah, that's correct, Judge, yes.
That's your position?
Yes, Judge.
Okay. Okay. Well, over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today, so you can litigate that as you see fit. But I certainly think she's entitled to a copy of the search warrant. Probably that's it at this point. So, defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is I need to give you a date.
Well, Judge, she said, nah. Check this out. I think I'm going to have to pop up to the YNW Melly trial. I'm definitely have to start a GoFundMe for this one. State of Florida versus Jamel Dimmons. State's memorandum of law regarding attorney conflict comes now to State of Florida by and through the undersigned assistant state attorneys and submits this memorandum of law regarding attorney conflict and comments as follows. On December 27, 2024, the defendant filed a motion for hearing to determine potential conflict. In this motion, it states the defendant's attorney, Raven Liberty, was informed on December 18, 2024 by Apple that on December 13, 2023, that her Apple account information had been provided to the Broward Sheriff's Office pursuant to a search warrant. Monday, January 6, 2025, this honorable court heard the defendant's motion. In addition, on January 6, 2025, the state filed a motion for a rehearing, reconsideration of defendant's or tenant's motion to compel disclosure of Apple search warrant related to attorney Raven Liberty. Within this motion, in paragraph 11, the state mentions that regardless of the details of the investigation, Ms. Liberty has an ethical obligation to withdraw even if the defendant were to waive the conflict in U.S. versus Pisonia. The court held that if the attorney suffers from an actual conflict so severe that it impedes effective assistance, counsel should be disqualified, notwithstanding defendant's desire to waive if the activity for which the attorney is investigated is substantially related to the charges against the defendant. Disqualification is necessary, notwithstanding the defendant's waiver. On Tuesday, January 7, 2025, this honorable court entered a written order ordering the state to provide a copy of the search warrant to the defendant to determine his potential conflict over the state's objection. Over the defendant's objection, this honorable court ruled it will review the search warrant in camera for potential redactions. During this January 7, 2025 hearing, this honorable court spoke to the defendant about how it was his decision and his decision alone to determine whether to keep Ms. Liberty as his counsel despite this conflict. It is not the defendant's decision. The United States Supreme Court has recognized that the Sixth Amendment right to counsel is circumscribed in certain situations. See Wheat versus U.S., explaining that the Sixth Amendment right to counsel is premised on the site that a defendant is entitled to receive a fair trial, though the adversarial process in the relationship between counsel and defendant must give way to that right. The United States Supreme Court also explicitly rejected the argument that a waiver of the conflict cures a violation of the Sixth Amendment. To the contrary, courts have a legitimate interest in ensuring the criminal trial is conducted within the ethical standards of the profession. We're at 161, therefore, the rules of professional conduct, including those rules of the State Bar Association, which govern an attorney's conduct, are of paramount importance and should assist in informing the judiciary about how to proceed. At issue here is the alleged criminal conduct involving Raven Liberty, one of Dimmons' four attorneys. Clearly, after reviewing the search warrant in camera, there can be no doubt that an actual conflict is present squarely involving the personal self-interest of Miss Liberty. Moreover, this alleged conduct, if true, involves multiple violation of the rules regulating the Florida bar. See Florida Bar v. Rude. Regulating, let me go down. I don't want to read all that. Anyways, the 4th District Court of Appeals has also recognized the superior authority and insight inherent in the trial's court purview to reject a waiver of conflict. See Cotto versus State. Court's authority to reject a defendant's waiver of attorney conflict based on counsel's prior representation of a state witness. In fact, the 4th noted in a footnote that if the lawyer's conflict encompassed counsel's self-interest, a waiver is precluded as a matter of law. Therein, the 4th DCA approved of the rationale in United States versus Fulton, where the conflict involved allegations of criminal conduct by the defendant's lawyer, regardless of whether the lawyer is ultimately found innocent. In Fulton, the court stated, second, even if the attorney is demonstrably innocent and the government's witness allegations are plainly false, the defense is impaired because vital cross-examination becomes unavailable to the defendant. Ordinarily, a witness' blatantly false allegations provide a rich source of cross-examination designed to cast doubt on a witness's credibility, but when the allegations are against the defendant's attorney, this source cannot be tapped. The trial court is obligated to protect the truth-seeking function of the proceedings by considering if defendant has effective counsel, even where defendant wishes to waive conflict. United States versus Moscone. Wherefore, the state hereby submits this memorandum of law to consider regarding the attorney conflict. So basically, they're finding out a way to keep that freaking... Do we even want to call it a warrant at this time? Or do we want to call it a golden ticket? What do we want to call it at this time? Because I thought judges sign a warrant, warrant gets served, people get the F out the way, they do their job, they try to acquire their evidence, and that's that. But at this current moment, no. And then on top of that, here's what I think. Here's what I really, really believe. Whether true or untrue, we're going to find out. But I really believe this has to do with YNW Melly's girlfriend. I do. They were talking about witness tampering and all of this stuff, and I believe what they're trying to do is either try to say that YNW Melly's girlfriend has been contacted by his lawyer or the girlfriend's mom. If you remember, when the trial ended, the mom was on the internet going crazy, talking about being threatened and all this crap and everything like that. And then they did the interview on Law and Crime. So I think, in my heart of hearts, I believe that's what's going on, is that they're trying to prove somehow that the lady of the team reached out to them and essentially witness tampered and try to figure out how to get them to not talk and all this crap or something like that, or even been in contact. They can more than likely allege that she's been in contact with that girl and she knew to tell that girl to basically bring your butt to court, sit up here and testify, and she didn't. So I think it's going to have to do with that or something to do with the jurors. Because if you remember, YNW Bortland, he's in jail right now, faces serious charges. Whether he gets found guilty or not, he's damn near screwed over because of the jurors. Because he had a freaking, and I believe it was on a paper towel that they had essentially put, oh, this juror right here, this juror right here, the makeup of the jurors and stuff like that, and even gave them nicknames. Now, to me, if I'm seeing that and I'm hearing that, I'm thinking strategy. I'm thinking, oh, let me get this amount of people, and all that stuff, and basically increase my odds. Because one thing is for certain, two things for sure. The older crowd of people, they ain't really rocking with the youth. Let's just be fair. You can take this back to your grandma, grandpa days with the Beatles and all of this crap. Y'all can go back to the Michael Jackson days. Y'all can go back to the early days of rap. Well, hip-hop at the time, the early days of rap with Dolores Tucker and all this. Everybody that opposed the younger generation has always been the older generation. If you look at the jurors in the YSL trial, right, who were the jurors that it seemed to make the most impact with? The younger jurors, because they have a better understanding of the youth. It's called peer-to-peer. So you have that instance right there, and I think that's what's going on. So it's either has something to do with the jurors or it has to do with the girlfriend and the mom or the mom and the girlfriend. Either way it goes, I believe that's what's going on. They're going to allege some big stuff, and you got to remember, they're going for disbarment too. But they put in the last motion that she may not have did anything. We haven't officially charged her, which is insane to say that all of this is speculatory and allegations. They haven't even charged her. So if I'm the state, and I don't think the YNW Melly prosecutors are watching this channel at all. I know the YSL trials were, but the Melly trial, I doubt this highly. But if I'm the freaking state, I'm going to charge her because this is looking bad. The judge has to do something. If this judge does nothing and he says, you know what, you guys are right, bruh, I need a new judge. I want this judge recused. I want him gone. His ball's about as small as pebbles. He ain't got a lick to stand on. And any judge that will sit up here and be basically run over like that, bro, they will be able to present the evidence how they want and bring in stuff that doesn't even matter and paint an illustration so bad that we gonna sit back here and go, damn, judge, you gonna let that go? You gonna let that one fly too? What are we doing here? Well, so at this current time, bro, I'm sorry. They want her gone. They want her off the freaking case. I didn't even see her being that damn good. But maybe what we're not seeing, they're seeing, and they're afraid of her. If that's the case, then that's the case. But if I'm Melly, I'm talking to my lawyers, and I'm telling them, what big dog can y'all add to y'all team? Kind of like how Johnny Cochran had all of his people. What big name can we add to the team to basically scare them into capitulation? Because at this time, Melly's going to have to get something that's going to get him out of here. I mean, get somebody who's going to get him out of here. Because as it stands right now, Brett, she damn near good as gone. I ain't going to hold you. The state is so hell-bent on this that it's holding up motions that are supposed to go through. And if it's holding up motions that's supposed to go through and they don't push these motions in down the line, Melly don't got a damn snowball's chance in hell. Whether he did it or he didn't do it, how it's supposed to go is justice is supposed to be served, where if he gets found guilty, that means that the state did their job, the laws are just, and he was found guilty. But as it stands right now, this more so seems like retribution because they couldn't close the case and they got the other lawyer the hell up out of here. So that's what I believe is going on right now as it stands. But we'll see, man, because at the end of the day right now, bro, it looks effing bad. But y'all let me know your thoughts on this one. Do you feel like Melly is being treated wrongly, or do you feel like, man, if that lawyer tampered with witnesses, she get what she deserved? Because there has to be a point where if she's guilty of this crap and it's black and white and plain as day, do we sit back and go, you know what, you was playing dirty. Shawty, you was playing real dirty. You get what you effing deserve. And if that's the case, man, I ain't gonna hold you. It just is what it is at that point. But y'all let me know, man. I don't know, man. I don't know. I just got theories. Do you think my theory is right? Think my theory is wrong? Or what do you believe? But I'll catch you on the next one. You want to win that Xbox or PlayStation? I know y'all about tired of this. But if you about tired of me playing this same old outro, then go ahead, hit the subscribe, hit that like button, run the likes up. More people will come. More people will subscribe. And then we're going to get rid of those. And we'll get back to giving out money. Yeah, man. We just hit 200K. We on our way to 300, man. Subscribe today so you can find out how you can win an Xbox or a PlayStation, man. The details are on the way. This is how you know somebody is literally going to be in the drawing. Robin Minter, check him out, man. All we do is go down and we look and we see his subscriptions. Who does he have? That's Seti Nash right here. What also happens, take that off. Top commenter. That right here. Public subscriber. So that's what you got to do, and make sure you share each video. And then you'll be entered to win. Shout out to Mike. Good luck. Subscribe, turn that bell, stay notified, and share to keep your people aware. I'll catch you on the next one.